Hello, my name is William Dale. I'm with the law firm of McChesney Dale in Bowie, Maryland. I'd like to talk a little bit about estate planning and what documents you would expect an attorney to prepare for you when you schedule an appointment to have an estate planning consultation. To a certain extent, estate planning involves a determination of how your assets are titled and how your estate, your asset holdings are structured. But the end result of an estate planning session with your attorney will be that you will have a number of documents that have been prepared for your signature that are designed to accomplish your objectives and contain your desires as far as the ultimate distribution of your assets. There really are four basic types of documents that should be prepared to accomplish your estate plan. One obvious document is a last will and testament. The last will and testament is designed to set forth to whom your assets should be distributed upon your death. Your will can include certain things such as setting up a trust after your death to make sure that your assets are used for the benefit of one or more of your loved ones. It can postpone the distribution of assets to the individuals that you would like to have receive your property ultimately. It can provide for a charity, but it's the basic document that sets forth how you would like your assets to be distributed. You also have the opportunity to name the person that you would like to serve as your personal representative. Personal representative is the individual or individuals, or could be a bank trust department, that actually accumulates your assets, pays your last bills, and makes sure that the requirements of your will are properly accomplished. So those are the basic components of a last will and testament, and of course your will can be a complicated document or relatively simple. Another document that generally is prepared during estate planning is one or more powers of attorney. A power of attorney is a document that authorizes another person, such as your spouse, your child, or a good friend, to handle your assets during the course of your lifetime. A power of attorney can be a limited power of attorney, such as a power that authorizes someone to sell your car, or it can be a general power of attorney that would authorize an individual to handle all of your assets just as you are able to handle your assets. A power of attorney is an important document in the event that you should become disabled and unable to handle your own affairs. If you don't have a power of attorney and no one is authorized to handle your assets, then it would be necessary to file for a guardianship with a court, and court involvement can be expensive and very time-consuming. So a power of attorney, or more than one power of attorney, are important estate planning documents. Another document that is generally prepared is called a living will, and often with an advanced medical directive. This is a document that states that you do not wish to be kept artificially alive in the event you are terminally ill with no hope of recovery. It also has a provision that can authorize another individual or other individuals to make medical determinations in the event you are not capable of doing so. Generally, it's important in that document to make sure that you authorize your doctors to release medical information to the person to make those decisions with a HIPAA release. Again, that is an important document that most clients want to have prepared when we're preparing other estate planning documents. A fourth document that you may or may not find to be appropriate for your individual circumstance is a trust, a revocable trust, for example. Trusts can be revocable, which means that you can amend them, change them, or terminate them during your lifetime at your own discretion. Or they can be irrevocable, and there are reasons for setting up irrevocable trusts. Those are trusts that, once they come into existence, you don't have the power to terminate them. And there may be some tax planning reasons to set up an irrevocable trust. A trust may be an appropriate estate planning document for you and your spouse, for your family, Although, in my view, it is not necessary that all estate planning clients set up trusts. It's important to determine what your objectives are, what your concerns are, how old you are, what your ultimate distribution scheme is, what restrictions or limitations on distributions you might have. And once we know the answers to all those questions, then we can talk about whether a trust agreement is appropriate for your particular situation. It may well be that the trust idea is just more complicated than is necessary in order to accomplish your goals. So whether or not to prepare, sign, and observe a written trust agreement during your lifetime is an issue that needs to be discussed and examined, but a trust is not an end-all, be-all answer to everybody's estate planning requirements. Those are the documents that you want to talk to your attorney about when you meet to discuss your estate plan and how to implement your desires. And your attorney will be able to explain to you the important provisions of each of these documents. Thank you for listening.